Recording in progress.
The nation's 45th president, Donald Trump, has been federally indicted in Miami by the United States Department of Justice, thus becoming the first ex-president to ever be federally indicted by the constitutional government that he once oversaw. We are continuing our coverage of this historic event here on Atlanta News First from our digital streaming desk in Midtown, and we are joined this afternoon to provide some commentary and some perspective on these historic, unprecedented developments by Lindsay Barron of Barron Law here in Atlanta. She is a visiting law professor at Emory School of Law in Atlanta. Lindsay, you're a former federal prosecutor yourself. You're now a private practicing attorney focusing on white-collar crime. What is a federal indictment, and how does this differ from the other cases in New York and here in Fulton County, Atlanta? How do these cases differ?
Well, so, the former president was indicted in Manhattan on charges stemming from his falsification of business records, covering up payments that were made to Stormy Daniels. This is completely separate conduct. This is more recent, all post-presidency conduct, what was just indicted in Florida. And it relates to his decision to take and then keep and then share some of the most classified, top secret documents that were in his possession as president, relate to national security, nuclear capabilities of other countries, Department of Defense information. So that is a crime. And then on top of that, once he learned that the federal government, specifically Special Prosecutor Jack Smith, was investigating his retention of those documents, his decision to try and convince his staff to hide or destroy those documents, to falsely represent that they had given over all the documents when they had retained a significant number of those classified documents, and to obstruct justice. And that's different from the Fulton County investigation, which is looking into his efforts between the election, the November 2020 election, and then the months following that to basically to interfere with the election in Georgia and to his call to Secretary of State Brad Raffensperger and other copies, and other conduct allegedly falsely claiming that that he had won the election and that it had been stolen.
Does a federal indictment from the U.S. Department of Justice carry any more weight than an indictment in Manhattan or any possible indictments? We don't know if Fulton County District Attorney Fonnie Willis will be actually criminally indicting the former president. She has indicated that there are historic charges, her words, not mine, coming this summer. But does a federal indictment carry any more weight? Is it more serious than some of the more locally oriented indictments that he is already facing?
Yeah, prison is prison. And so I would say that any indictment in which you're facing a potential term of prison, it doesn't matter if it's state or federal. The main difference, after you get past conviction, the main difference between federal and state is that there's no parole in the federal system. So if he is sentenced, and some of the charges, the indictment was unsealed, I think within the last hour, and I've skimmed over it. Some of those charges carry, potential 20 years in prison. And so if he is sentenced to 20 years, he's going to serve 20 years. And, in the state system, obviously you can apply for parole, but that doesn't exist. That was abolished over 2 decades ago in the federal system. So that's the main difference. But it's not any more serious, because at the end of the day, if he goes to prison, he goes to prison. It doesn't matter whether it's state or federal. It could significantly impact his ability to serve as president again, which he hopes to be able to do.
And we know that some of the indictments have been unsealed, as you just said. within the last hour. You mentioned that you had skimmed over them. What kind of insights? What are we looking at? We're only now learning the content of some of these indictments. What have you been able to ascertain from your examination of them so far?
Well, so substantively, the initial reports were coming out uh, yesterday, and even more today, that he had in fact been indicted, summarizing what the possible conduct was, the charges. And so a lot of what's in that indictment is what we expected to see. The charges are a little different than what I expected, because there are a number of charges that they could have brought to cover this same conduct. And so Jack Smith has chosen some unusual statutes that we don't see indicted very much. But the thing that was really surprising to me is that the early reports, even as early as 2 hours ago, they were all saying that he was charged in 7 counts. The indictment charges 38 counts. 31 of them all relate to this issue of retaining classified documents. And then there are several obstruction related counts. And so that was surprising to me, because I was expecting to see 7 counts, not 38.
The former president continues to call this a quote unquote witch hunt and has pointed to other former presidents obtaining classified documents. What's the difference between his case and some of the others that he is alleging, such as current President Joe Biden obtaining and keeping classified documents, and also former President Obama? What makes these allegations more serious in the eyes of the DOJ?
Well, the thing to me that highlights exactly how serious they take this, like I mentioned before, they had some charging decisions they could have made, a lot of different statutes. So one of the charges they could have brought is 18 United States Code 1924, which is the retention of classified documents. And that's any classified document. And it carries a potential sentence of up to 5 years per violation. They didn't choose that statute. They instead chose a different statute that relates solely to national security documents, and it carries a potential 10-year sentence. And what that tells me is they see a material difference in retaining classified documents, which could be about anything. Documents can be classified for all kinds of reasons, but he retained top secret classified documents. And those are documents that directly relate to national security. And so they chose that particular charge for a reason. They're trying to draw that line between the retention of classified documents and top secret security related documents. And another thing that's different, or at least the way the indictment reads on first pass, is that simply having documents in your possession, if you're not aware that you have them, or if you didn't take them knowingly and willfully with the intent to retain them, that may not be criminal. If you look at the indictment, and it is 49 pages long, it is detailed. It's what we call a speaking indictment. They have gone into exhaustive detail to explain exactly what their evidence shows and detail out verbatim quotes from things that he has said, from things that he told his attorneys allegedly. And I think the reason why they did that is because they knew that with this indictment, they needed to make their case early. So that indictment reads as their evidence. You can read it and know exactly what they found, exactly where they see this case going. And I do think people should read it, because it's fascinating. I knew that it was going to cover some of that conduct related to national security documents, but it's pretty damning. And that was not an accident, them choosing that particular statute.
In terms of where this case is going, we're continuing our coverage here on Atlanta News First regarding Donald Trump's historic federal indictment. We're talking with Lindsay Barron, who has her own law firm, Barron Law, here in Atlanta. She's a visiting professor of law at Emory University, former federal prosecutor herself, and now an attorney specializing in white-collar crime. The former president is certain to make his appeal to this case. I believe he's scheduled to appear at a federal courthouse in Miami on Tuesday. If he appeals, will this appeal eventually make its way back to the 11th Circuit Court of Appeals, headquartered in Atlanta?
Well, I mean, he doesn't have the right to appeal yet. That has not happened. So what's going to happen on Tuesday? It's called an arraignment. And that happens in every criminal case. The defendant comes to court, they are officially presented with the charges against them, and he will enter an initial plea. Probably not guilty. That's what most people do. I think we can certainly expect that in this case. And then the judge may hold a bond hearing there. I doubt the government's moving for detention. I doubt they're going to try and keep him in jail while we're waiting for this trial to happen. And the reason why I think he's going to remain on bond is he's being allowed to show up on his own. He was issued a summons. And that is basically something that the court signs. This one was signed by Judge Eileen Cannon, telling him to come to court on Tuesday. Most often what happens is that when someone's been indicted, an arrest warrant is signed by a judge and they are arrested and brought to court. So the fact that the government allowed him to show up on a summons rather than being arrested and brought to court tells me that they don't consider him a flight risk or a threat, and that they're probably going to support him remaining on bond. So this is just going to start the process. And then the government will hand over all its evidence to the defense. We'll probably see a bunch of motions back and forth. There'll probably be a motion to dismiss the indictment. There's going to be a lot of litigation and then presumably ultimately a trial. And only after the trial and after he's sentenced will he have the opportunity to appeal. And so that's a long way off. We're
That is a long way
off.
off. I mean, how long of a process are we looking at? Is this going to stretch into well, we're already in the campaign season of the 2024 election. What kind of timeline are we looking at?
It could be, it is not unusual for a federal case to take a year or more, and that's in simple cases. So in a case like this, where we can anticipate a lot of litigation before trial, the lawyers are going to do everything they can to try and delay trial, to try and get the judge to throw out the indictment. Probably going to see what we call suppression motions to suppress the evidence that was seized from Mar-a-Lago. They'll probably file motions claiming executive privilege. We know they've already tried to litigate that issue. They have not really litigated it in full. It was litigated, you may recall, about a year ago when the subpoena was first issued. And same judge, Eileen Cannon down there, appointed a special master to oversee the collection of documents because Trump's lawyers were saying, look, these documents, it's executive privilege. We don't have to hand these over. And so she appointed a special master to review those documents and determine if they were subject to privilege or not. The 11th Circuit, which is the appeals court that oversees Florida, Alabama, and Georgia, reversed her on that and said that they have to hand over all those documents. But I don't think we've seen the last of the executive privilege defense. I think he will raise it again. And so all of those things are just going to delay this process. And so I don't see a world in which this trial happens within the next year. It could, but given how much litigation I anticipate, I would say it's, we're probably looking deep into 2024, maybe 2025 before we even have a trial.
And that is, could conceivably be going on at the same time we're holding a presidential election. I mean, this is truly unprecedented. Just give our viewers some final thoughts and observations. You have obviously seen the indictments and are becoming more and more familiar with them. Tell us some things that we should be watching out for over the next several days, weeks, and months.
Well, one thing I think to be aware of, we know that he's facing potentially 4 total indictments, separate conduct. So we've already seen one, that's Manhattan, that's related to the Stormy Daniels payments. We've seen this one, which relates to the documents at Mar-a-Lago. We know that Special Prosecutor Jack Smith is also looking into the January 6th insurrection and potentially efforts to interfere with the election. And then finally, we have the Fulton County grand jury related to issues solely in Georgia, although we think that DA Willis may be looking at election interference in other states, but it all ties back to Georgia. And so the reason why that's significant is that it's not uncommon for someone to be indicted federally and at the state level for the same conduct. That can happen because they're separate sovereign entities. But in this case, because these are different entities looking into different charges, there could be 4 separate terms of imprisonment that would run one on top of each other. So let's say that he gets somewhere between 10 and 20 years in the federal case, and he gets maybe 3 years in New York and 3 years in Atlanta, and 3 to 5 years in a potential DC indictment related to January 6th. Those would all run on top of each other because they're not stemming from the same conduct. And so he could be looking at, I mean, who knows how much more time he has, to live, but we're looking at a potential, decades and decades long total sentence that he's facing. So what implication does this have for the presidential election? So the election obviously is next November, 2024. And let's say that he wins and this case is not over, or there are other cases that are still pending at that point. And let's say he's convicted in at least one of these 4 and is sentenced to serve time. He cannot serve that time and serve as president at the same time. And I don't see a mechanism through which his prison sentence would be deferred while he's sitting as a U.S. president. And so what would happen is he'd have to report to prison. He's clearly unable to run the country at that point. And so the vice president then becomes president. And so I think that this could really cause a constitutional crisis. I don't know that that's how it's going to play out. I think the Supreme Court may ultimately have to decide that because I think it's going to be litigated if it comes to be. But we are looking at something so unprecedented and so unusual that, who he chooses to be his vice president, we know it's not going to be Mike Pence, but whoever he chooses could potentially be our next president, and in fairly short order.
And it is truly just mind-boggling and staggering in terms of the political implications of everything that is going on. And we are so thankful that Lindsay Barron, Barron Law here in Atlanta, who is also a visiting law professor at Emory School of Law, has been able to join us this afternoon as we continue to cover the unprecedented legal challenges and federal indictment of former President Donald Trump. Thanks to Lindsay Barron for joining us, and thanks to all of you for watching our continuing coverage on Atlanta News First.